cover just a little bit of history here in the file. Previously, Mr. Hartel from the Public Defender's Office represented Mr. Kirchner. Mr. Mankiewicz on behalf of King and King came in to represent Mr. Kirchner. There was a request for a criminal responsibility evaluation. See, that looks like it was received in my office on January 7th. And we set it out for today for a final pretrial conference. Because it was for criminal responsibility and not competency, there wasn't a requirement to have it conducted within, or I'm sorry, an evaluation review. Mr. Did you get a copy of that?
We both, yes, Your Honor. I received a copy of the report, and so has my client. We've gone over it. We both have read it, Your Honor. Just to back up a little bit more, I was retained after it was bound up to circuit court.
Oh, okay.
And I believe it was Mr. Hartel that did request correctly the evaluation.
Okay, good enough.
Thank you.
Key issue is also you're not asking for time for your own independent evaluation?
No, Your Honor.
All right, thank you. So again, we're set here for the final pretrial conference, and I can tell by this paperwork, we anticipate a plea of some sort. Mr. What's your name? Carnes? Go right ahead and tell me what it is.
Your Honor, it's my understanding that defendant will plead no contest to an added count of attempted felonious assault, and the people will dismiss the 3 counts of felonious assault. There's also, I'm going to recommend no additional jail at the time of sentencing, although it's not spelled out there. I do plan on recommending probation. The reason for the no contest plea is potential civil liability.
Thank you. Mr. Mankiewicz?
Your Honor, I would agree with that. In addition to civil liability, there's also a memory. There was medication, prescription medication that affected memory and recall.
All right, thank you. All right, Mr. Kirchner, have you heard what the attorneys have described to me as today's resolution? All right, make sure you, that's just, oh, you don't need to stand up, just make sure you speak.
Yes, sir.
All right, thank you. Is that how you wish to resolve it? Is that how you wish to resolve this? Maybe you're not happy about it, but is that what you're gonna do? Let's do it that way.
Yes, sir.
All right, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth? You may lower your hand. Looking back on July 7th of last year, Mr. Kirchner, were you on probation, parole at that time at all? And were you on bond pending any other felony charges anywhere? All right, thank you. Now, you are currently charged in this felony information with 3 counts of assault with a dangerous weapon, also known as felonious assault. And apparently they each involve and allegedly involve a .22 revolver. Each one of those would be a felony punishable by up to 4 years and or up to $2,000. However, each one of those 3 counts will be dismissed today if you enter a plea of no contest to, and I accept that plea, to an added count 4. That added count 4 would be a single count of attempted felonious assault. Mr. Carnes, just so I make the proper finding, I see that the original counts, they involve different individuals. I want you to tell me which one you want me to focus on. It doesn't matter, but I just need to make a finding.
Your Honor, I'd say count 1.
All right, thank you. All right. Now, an attempted felonious assault would bring the charge down from actual felonious assault, and that would bring it down to no more than 2 years in prison or no more than 1 year in the county jail and up to $1,000 in fines and costs. Do you understand that? All right, good. Now, by entering a plea of no contest, as you may have heard me describe to the last case, last defendant, that means you're not going to have a trial. Does that make sense? Now, for this court to accept a no contest plea, I can do so in a couple instances, and one of them is memory, one of them is potential civil liability. Here's the key point. Instead of you telling me what happened, I'm going to look at something such as a police report. And when I do that, you can't come back and argue that whatever's in that report is wrong. Okay? And I see you shaking your head. Yes, remember, I need a verbal answer.
Yes, sir.
That's only because Nancy's got to do some typing. All right. Because sometimes people try to come back and say, well, I don't agree with that. Well, if I'm doing it because you can't remember, I can't go back and change it if you say, well, that didn't happen because you don't remember. And that's okay. I just need to make sure that you appreciate and understand the differences between a guilty plea and a no contest. Do you have any questions for me about those differences? No? All right, thanks. Now, Mr. Mankiewicz provided to me a piece of paper that I'm holding up now, and at the top it says advice of rights, and at the bottom appears to have your signature. Is that your signature at the bottom?
Yes, Your Honor.
Now, did you read through these rights before you signed?
I did.
And did you understand what you read? And again, even more importantly, to understand that if you plead no contest, and I accept that plea, you'll be forever waiving these rights as they apply to this particular case.
Yes, Your Honor.
Now, you also will be given up the right to come back and claim that the plea was the result of some promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements, or deals that get you to plead no contest that we haven't talked about?
Other than family pressure, no, Your Honor.
No, all right. Well, here's the key question then. That guides me to ask this question. You may not like it. There might be people telling you they want you to do something, but are you making this choice of your own free will?
Very much.
All right, thank you, Brett. That's the key point. Now, I have no doubt that Mr. Mankiewicz has talked to you about sentencing and possible sentencing. Has he talked to you about something called the Michigan Sentencing Guidelines? Chart that says here's what the guideline, the minimum could be or should be.
I don't know if we talked about it in detail, other than I was pointing out that it's not mandatory. And
All right.
he is very aware that this court is the sole sentencer,
All
or
right.
sole, if that's a word.
That's all right.
And
Makes me
this
sound
will
good.
be up to the judge. He's very aware of that, and we've
All right.
gone over that as part of the plea.
All right. Is that true, Mr. Kirshner?
Yes, Your Honor.
All right, the key here is I decided the sentence and I don't really know much about it because I haven't read this report yet. So I don't know anything about it and I can't tell you what I'm going to do for sentence. You understand? Okay, good enough. Now, again, I have no doubt you've been able to speak to Mr. Mankiewicz about the charges and your rights and all the options. Is that right? And has he answered all your questions? All right, are you satisfied with his representation is the key thing here?
Very much.
All right, good, great, thank you. All right, so I've gone over your rights, I've gone over the charges, and I've gone over the pretrial agreement. Therefore, as to added count 4, attempted felonious assault, how do you plead? Again, I anticipate that to be no contest. All right, thank you. Now, that's not me telling you what to plead. It's just that sometimes if I don't remind people,
I'll whisper it into you.
yeah, they always watch too much TV and use the word guilty. So, all right, no contest. All right, before the court can do that, I need to take a look at an exhibit. I have what is now marked as Defendants Exhibit A. It is a Wexford County Sheriff Incident Report number 83-2501223. And it consists of 5 pages plus a supplement number 1 of 3 pages. And I'll turn to Mr. Mankiewicz. It's got your sticker on it. Are you asking the court to accept this?
Yes, Your Honor, I ask the court to accept it and use it to define the basis for the plea, Your Honor. I have, from Mr. Kern's knowledge, I just made some quick pen highlights to find some elements.
That always,
So,
it's always well appreciated because it helps me. Mr. Carnes, are you stipulating to the admissibility of this exhibit?
yes, Your Honor.
Thank you. All right, and Mr. Carnes, to agree that the interest of justice based upon memory and or even more importantly, civil liability satisfy or justifies the taking of a no contest plea?
Yes, Your Honor.
And have you been able to speak with the victims in this case?
I have, Your Honor.
All right, and did they express support or, or
Mixed feelings?
it doesn't matter, as long as you
Yeah,
talk to them
I've
about
talked to
it.
them, yes.
All right, that's all I care about. I'm not in charge of doing that. All right, thank you. Defendant's Exhibit A is hereby admitted. Again, it consists of those 8 pages. The first thing I'm going to make a finding about is that this report satisfies the issues of venue and jurisdiction, specifically focuses on a date of July 7th of 2025 with a location out in Cherry Grove Township here in Wexford County. And because I've been told that we were going to make a finding, or my findings are to be relevant to count 1. 1 second. That involves victim Angela Kirchner and side Exhibit A, beginning on page 5, continuing over onto page 2. That's where there's a statement from Ms. Kirchner. All right, and specifically on page 2 in the, like it's, well, the first full paragraph appearing toward the top talks about the events involving that particular individual. One moment, let me take a look at the supplement to see if there's anything further I need to know. I don't think I need to know anything further. Mr. Carnes, are you satisfied that the defense exhibit A that has been admitted satisfies the elements for the added count, allowing the court to take, of course, a plea to a lesser included? Does it satisfy added count 4?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Michigan Code 6.302?
Yes, Your Honor.
Mr. Mankiewicz, do you agree with all 3 of those statements?
Yes, Your Honor.
The court agrees and finds, first of all, that the interests of justice do not require the defendant to recite a factual basis based upon potential civil liability and potential memory issues based upon medications. The court also finds that the information contained in Exhibit A satisfies the elements for count 1, which therefore allows the court to accept a plea to the added count 4. Therefore, the defendant is found guilty of added count 4. And counts 1, 2, and 3 will be dismissed at the time of sentencing. Mr. Kirschner, we should be back here in about 4 weeks for sentencing, maybe 5. We do them on Monday mornings. Between now and then, an agent of the Michigan Department of Corrections is going to prepare what's called a pre-sentence investigation report. One of these reports must be prepared anytime someone is convicted of a felony in a state court here in Michigan. That report will include a description of the offense, a description of the pretrial agreement, any statements, information you make or provide while preparing the report, as well as information about any prior criminal history, if there's any statements from any victims in the case, as well as information about guideline scoring, which again is not mandatory, and makes a recommendation as a sentence, which again is just a recommendation. You understand so far?
Yes, sir.
All right. When you leave this courtroom, I know Mr. Mankiewicz knows what to do, but I'm just going to say it out loud. You need to report to the Department of Corrections, which is downstairs on the first floor. They're also known as the probation or parole office. So they're going to give you a packet. You're going to complete that packet and turn it back in. They will set you up for an interview. You have the right to have Mr. Mankiewicz appear at that interview. Mr. Mankiewicz will get this report generally about 10 days, maybe 2 weeks prior to coming back here for sentencing. He's going to have to meet with you and go over that report, so you must make sure you maintain communication with him. Each side has the right to come back to this court and request corrections, make objections to the comments, the scoring, and all that. That's why he needs to meet with you. Okay? You're going to want to make sure that all the information that you provide in there is true and accurate and complete. Now, of course, when it comes to the description of the offense, I don't expect any statement based upon this being a no contest plea, so I'm not making you provide that statement. But the other stuff about your history and family members and medications and things like that, I want to know about those, because Just want to know. And they ask you those questions. Any objection to the continuation of bond, Mr. Carnes?
No, Your Honor.
And Mr. Mankiewicz, anything further on behalf of the defendant?
No, thank you very much, Your
All
Honor.
right, great. Thank you very much. We're adjourned.
Thank you, Your Honor.
Oh, Mr. Mankiewicz, your exhibit, sir.